All right, everybody. Hello, hello, hello. Good morning and good afternoon, everyone. And welcome to today's Lawpath webinar, Contract Clarity, Common Legal Mistakes That Cost Small Businesses. My name is Joel Comerford. I am part of the Lawpath team and I am your webinar host. Christmas is looming. It's November. The weather is lovely. It's a good day. I'm hoping everyone else is having a lovely day wherever you are. Hopefully, those who did participate in the Melbourne Cup the other day aren't reeling too much and your head's not still sore from the day. Now, before we jump in, if anyone here is new, you can go ahead and say hi in the chat. I'll make sure that I reach out to you personally afterwards to thank you for coming and introduce Lawpath in greater detail if you wish. But if you are new, Lawpath are Australia's largest legal and accounting platform for small businesses. Over the last decade, we've helped over 500,000 businesses start and scale, saving over 500 million in legal and accounting fees. We offer everything from legal document templates and company registration to on-demand legal and accounting advice, all in one place for a fixed price. Our mission: to make expert business support simple, affordable, and available on demand. Today's speaker is Sahil. Sahil is one of the very experienced Lawpath lawyers over here at Lawpath Legal. If you've used Lawpath recently, you may have already spoken with Sahil. He's a commercial lawyer with over 5 years of experience helping startups, sole traders, and SMEs across industries like tech, hospitality, retail, professional services, and NDIS. His focus is on helping businesses avoid costly legal mistakes and get clear, practical legal advice that helps them move forward. So, small businesses run into legal trouble not because they ignore contracts, but because they sign them too quickly and don't realize what's missing. So, in today's session, Sahil will be walking you through the most common contract traps that small businesses fall into, legal must-haves that every agreement should include, risky phrases like reasonable effort or all losses and how to fix them, real life examples of costly contract mistakes, and what steps you need to take today to review and clean up your contracts. So we're hoping by the end of the webinar, you'll walk away with a clearer understanding of contract risks and the practical tools to fix or avoid them altogether. So before we jump in, I want to get a bit of traction going with everyone. So a question for you all. Anyone who wishes to participate, that'd be great. How many of you have signed a contract in all the time you've been a business owner, whether new or pre-existing? How many of you have signed a contract without reviewing it properly? So for me, go ahead and throw your response in the chat. It'd be very interesting to see what you guys have to say. From my perspective, I'm over with the business registration team and the sales and a little bit of the marketing team as well. What I deal with most of the time is people calling in and having to deal with an issue like this. It's always out of reaction, we find. They've maybe come to Lawpath to get themselves a free doc, or they've gone elsewhere and they've made a document off Microsoft Word or ChatGPT. And they've said, you know what, this looks good. I'm trusting the AI is going to have all the information I need. They jump into it, they sign a deal, and the client doesn't pay them, or there's an issue with fair work for an employee, and they say, I did everything right, I reviewed the contract, but there are just some key clauses and some terminology that you're missing. This is essentially where Lawpath usually come in. If you are autonomous with your contract creation and you don't necessarily need to use us for the document building, at least having a lawyer to come in there and review what you're doing, both with new documents or pre-existing. What people like to do in our legal advice plan is have our lawyers sit there and go, let's have a look at all your existing documents for your business, just to make sure there's no legal gaps. This is what we specialize in. So if anyone here has come to the webinar hoping to get a bit more insight into how Lawpath might be able to help you, you've definitely come to the right place. And then later on in the this session today, guys. We will have a Q&A, so you can go ahead and throw some questions, direct those at Sahil towards the end. We do have a Q&A box in the actual Zoom call, so if you want to chuck your question in there, we promise we'll get round to it at the end. And we will also be offering some wonderful Black Friday deals. Today, all of our deals drop, so you're never going to get cheaper deals than today. If you're trying to get everything done before the Christmas period, now is the time, but we will go ahead and get into that later on. I dare say, without any further ado, it is time to proceed with the webinar. So thank you everyone for attending, and Sahil, go ahead and take it away.
Thank you, Joel. Good to see everyone. Thank you so much for attending. My name is Sahil. I am a commercial and startup lawyer here at Lawpath. I must have met a bunch of you guys in the past, but if not, it's lovely to see you. I'm here to talk about why contracts go wrong. My bread and butter is contracts. That's pretty much what I'm dealing with all day, every day, with all different varieties, all different sorts of contracts, with varying businesses. Some just starting out, some in the in the peak of their busyness, and some maybe towards the end of their business, towards the exit stage. And so, in terms of why contracts go wrong, we're going to start talking about things. I think it usually comes down to three things in my experience, at least. So, firstly, vague terms, phrases like as soon as possible or to a reasonable standard. They sound fine at the time, but when something goes wrong, they create endless arguments, we know, and everyone's always arguing about what was promised before versus where we're at now. So vague terms is a problem. Secondly, missing clauses. So people often forget to include some key protections. Things like termination, payment, or liability clauses all the time are missed. And so those are the ones that protect you when things go south, and they're incredibly important. And finally, it's the rush sign-offs. It's the classic, just sign it so we can start the work. Let's just get it done. I see this constantly with small businesses all the time. They're eager to move quickly, but signing without legal review, obviously, as we know, can expose you to serious risk. So I think really contracts go wrong not because people are doing the wrong thing, but because they're probably moving too fast or they're relying on unclear language. So these are really, really critical when you start. Now we're going to rewind a bit. We're going to find out what are the actual legal requirements for a contract to be considered valid and enforceable in Australia. And there's actually four key ingredients. A lot of you guys might have already learned this earlier, sometimes at school, sometimes at uni, sometimes just in general life. But we're going to take it down to the four key basics. So firstly, an offer. So someone proposes something of value. For example, I'll provide you with marketing services for $5,000. That's my offer. In these, you got to make sure you record the entity correctly. That's also a common issue that I see. The second facet of a contract is acceptance. So the other party has to actually agree to those terms, ideally in writing. Email acceptance is also acceptable from time to time, but it's important to be clear. The third key piece of a contract is consideration. So that's the legal way of saying something of value is exchanged. It's usually money, but it could be something else. It could be something like providing services in return. And then finally, the intention to create a legal relationship. So both parties have to actually want to or intend for the deal to be legally binding. That means it can't just be a casual or a handshake understanding, back of the napkin kind of thing. We need to be really, really clear that all four of these, going back to where it's going to be offer, acceptance, consideration, and intention for a legal relationship. And so a quick example, if I say I'll buy you coffee next week, that's not a contract, right? There was no one accepted it. There was no consideration. But if I say that I'm going to pay you $200 for catering next Friday, and then you agree to that, that's enforceable. That's me making an offer. You accepted it. There was consideration, and we intend to be legally bound by this. So that's a clear contract. And now we're going to talk about contract mistakes and traps. There's so many of them. We're going to try and wrap our head around them. Firstly, uncapped indemnities. Now, these clauses make you responsible for all losses, even ones that you didn't cause necessarily. For example, I had a client who signed a supplier agreement. There was an uncapped indemnity in there. Now, when the supplier's mistake potentially inevitably causes a loss, the client is still going to be liable. And the question you need to always ask is there a financial cap or a time limit? When I say uncapped indemnities, I mean to say that you are holding somebody else responsible uh, in case you are sued because it was their mistake. And it's important to cap your liability. Ideally, we like to cap it to the value of the contract, so the amount that you're getting paid in that contract. So let's say I'm getting paid $20,000. Ideally, my liability cap is also $20,000 so that I can sleep at night knowing that worst case scenario, um, most likely I'll be liable to pay a maximum of 20 grand as an example. And so a lawyer can help you kind of negotiate that in, or you can negotiate it in yourself. Another thing is one-sided termination rights. So if the other party can walk away really easily, but you can't, that's a clear red flag to me. So you got to make sure that your termination clauses are mutual and fair. Often, if they're mutual, they will be fair. Automatic renewals, I see this constantly, especially with SaaS-based businesses and service contracts. Unless you cancel early, sometimes even 30 days or 60 days before expiry, it automatically renews for another term. And so that is a catch-all for a lot of different people. Although with the introduction of unfair contract terms or stringent unfair contract terms more recently, technically the other party should be advising you if you're coming up to an automatic renewal, and they should give you that opportunity to opt out if you want to. So something to keep in mind. And also it's a good idea to set calendar reminders for those renewal dates always. And then the last one here is ambiguous language. So for example, phrases like best efforts or reasonable endeavors, they sound harmless, they sound amicable at the time, but in law, they're actually wide open to interpretation. If you can't measure it, you can't enforce it. That's usually the rule. So it's important that you make sure that anything that is important is defined, it's not ambiguous, or get a lawyer to check it for you. Um, the next part of this is just risky wording that you should watch out for. So this is where the devil really hides. I mean, in the wording, certain phrases can weaken your contract without you actually realizing. So some common examples, I've gone through some of these already, but you'd consider reasonable effort to be risky wording. A better alternative to that would be deliver within 5 business days. As you can see, it's defined, it's measurable. Um, Even when you say as agreed between the parties, that could be considered risky and ambiguous compared to as outlined in Schedule A, where you can clearly see exactly what you guys are agreeing to. Often when one party has discretion, they might say, at our discretion, we can decide X, Y, and Z. And the ideal point of view is to have subject to mutual written agreement. So we both mutually decide to do something and we put it into writing. Um, these are really common examples, and especially that last one around no liability limits, which I mentioned before. Ideally, we don't want to leave out any caps on liability. This can expose your business to kind of unlimited financial risk, which would be obviously detrimental. So I think it's a very simple fix, but it's something that you need to do to put in a liability cap. And just going back to that as well, sorry, I had a client where the entire disagreement came down to what reasonable time meant. And one party, my client thought it was 2 weeks, and then the other party thought reasonable time would be 2 months. And this is a clear example of kind of where it can be really, really risky. And so it's important that you train your eye to look over for these kind of vague, open-ended words, or engage somebody that is able to do that. So let's make this practical with some real world examples. So example one, the unclear NDA. A startup shared their product concept under an NDA that didn't actually define confidential information. That is critical. So the other party that was party to this NDA reused the idea, and legally the startup actually had no protection because, again, confidential information was not defined. Therefore, what are they actually protecting? Any court of law would listen to that argument and actually try and interpret whether the law applies here because the contract is so unclear. Example two is the auto renew trap. So a freelancer forgot to cancel a contract that actually renewed automatically, and they were billed for another full year and they couldn't get out of it. So you need to make sure that you're very, very well aware of clear notice periods, set reminders for yourself. But also, if you are in this situation, you should also know your rights. So technically, with the unfair contract terms, I mean, they should not be forcing you to automatically renew your contract if you have not been notified that that renewal is upcoming. So keep that in your back pocket. And if it ever does come up, you can engage a lawyer or you can just do a little bit of research around unfair contract terms and pull that out of your chest and kind of use it in terms of trying not to commit yourself to that extra year. And then finally is the reasonable effort clause. A client claimed a project wasn't delivered to a reasonable standard, but the contract had no objective measures, and it's turned into a dispute over refunds. And this happens all the time, especially recently, where people are drafting their contracts using ChatGPT, and which is, getting knowledge from AI is totally fine, but at the same time, making sure that it's drafted correctly. So ChatGPT would often leave them vague and ambiguous clauses, such as this one talking about reasonable standards, but no one better than you and the other party know exactly what the expectation is and what the standard should be. So the best thing you can possibly do is to actually measure it, whether there's KPIs, whether there's certain deliverables you expect by a certain date. Your contract should be as detailed as you can be in that scenario. And that is literally because the contract is to set expectations. Everyone needs to know their obligations, and they need to understand that this contract will be legally enforceable if these obligations are not met, essentially. So the lesson here is obviously replace vague standards with measurable criteria, have delivery timeframes, have scope milestones, whatever you need to be able to ensure that your job is done. And then we'll talk about dispute prevention tactics. So how do we actually stop these disputes before they even start? And again, a lot of this, what I'm saying is a bit of repetition, but in terms of number one, you should define everything clearly. Use precise wording for deliverables, timeframes, and payments. There's no assumptions. I see so many assumptions in contracts that are drafted and sent to us to review. And, if I start redlining through them, it's like, what does this mean? What does this mean? How do you know this is achieved? How many sessions do they have to deliver to you, et cetera, et cetera. So it all comes down to being as specific as possible. If you know that you're hiring a consultant to deliver services to your business, you should make it clear that, for example, it would be 8 sessions, 1 hour each, and this is going to be the agenda for them. Because what happens is if it's not defined, if you just say, let's say, okay, we're going to have 8 sessions, that's it. If the consultant might deliver a 15-minute session and then maybe a 40-minute session after that, that may not be relevant to what you need. You need to define it as much as possible. Secondly is including a dispute resolution clause. So add the ability to go to mediation or arbitration before any court proceedings to save time and cost. Now, this will benefit you, especially where you have done something wrong or something against the contract or something against your obligations. Even by having a dispute resolution clause in there that says, okay, if anything goes wrong, we're going to spend 14 days to try and go through good faith negotiations. We're going to talk 101, try and get it done that way. If that doesn't work, we're going to go to mediation. We're going to have a third party independent mediator that's going to help us resolve our problems. Again, this is the cheapest and cost effective solution basically for your business. If that doesn't work, then we go to arbitration, which is more of a binding decision by an expert. Again, it's a third party, but it's an expert in your industry that is going to deliver a binding decision. So whatever they say will go ultimately. And what we are essentially trying to do is we're trying to reduce how easy it is to get to court proceedings. Court proceedings is not necessarily good for anyone. It's expensive. It's uncertain. We don't know what's going to happen, and therefore you also don't want to be in that position where somebody can just take you to court if let's say there's a minor disagreement or some sort of obligation issue, anything like that. So it's really, really important that you have these dispute resolution clauses in your contract and making sure that it's easy to follow, easy to understand, and that this process exists. The third one for you is setting notice and termination rules. So outline how and when each party can actually exit the agreement. You should know how long are you committed for. I've even seen contracts where the term is 10 years long and there's no termination clause or there's no way to exit, which is a massive red flag. Why do you want to be committed for 10 years without having the ability to get out, right? So always have a termination clause that makes sense for you, whether it's 60 days notice or 90 days notice or anything else like that. You need to make sure that, you are fully aware of when you can leave the contract, as well as when the other party can leave the contract. Sometimes you want to make sure the contract goes as long as possible. So you need to make sure that the notice period works for you rather than just having a 2 week notice period. Maybe you need a 90-day notice period to be able to deal with your cash flow, to be able to deal with the wind down of a certain service no longer being provided, as an example. So set notice and termination rules, and that will prevent disputes. And then finally is review your contracts regularly. I know so many clients as well where the contract is just going ongoing for years and years and years, and no one's ever reviewed it. No one's checked whether it's still in line with the law. It's really important that contracts aren't your set and forget documents. You should revisit them every 6 to 12 months to make sure that they're still relevant. We know that businesses evolve, relationships change, and what made sense a year ago, it might expose you to risk now. So it's important to be really, really careful there. And now we'll talk about legal must-have for small business contracts. These are very basic but important clauses that must be in your contracts, right? So I'll go through them. First one, payment and delivery terms. So you need to define what's being provided, what's the scope of services, when are they being provided, and what's the price? How much? Is it including GST? Is it excluding GST? And what are the payment terms? You have to pay within 14 days, 7 days, 60 days. It could be anything. And so this would just prevent your he said, she said kind of disputes. And so that's why it's really, really important. Limitation of liability, again, it sets the maximum amount that you could owe if things were to go wrong, essentially, right? So it caps your exposure to a fixed amount so that one mistake doesn't bankrupt your business. It is critical to have a limitation of liability clause, in my opinion. Indemnity clauses. So indemnity clauses outline who pays for losses or damage. So you limit your obligations and make it mutual wherever possible. So a really good example for like that happens all the time is let's say a principal engages me, a contractor, to do some work. I engage a subcontractor to perform some of that work on my behalf. Because I am the only one that has a contract with the client, I will be liable to the client if anything goes wrong. However, I know that the subcontractor is the one doing the work for me. Therefore, in my subcontractor agreement, which is a contract, the subcontractor should indemnify me for any of their wrongdoing. So what that means is, let's say something goes wrong, my client comes for me, tries to sue me, because the subcontractor messed something up. If it's the subcontractor's fault and our contract says that they indemnify me, that means they will cover for me in the event that I am sued, right? And that is because they have been at fault for their wrongdoing, but they don't have a contract directly with the client. Therefore, the client can only go through me. I hope that makes sense, but indemnity clause, super duper important. Make sure it's included. Confidentiality, obviously, we all know this, protects sensitive business information, client data, trade secrets, especially where you are sharing a lot of data with, like a service provider that's dealing with tech-based issues or tech-based projects. Essentially, they need to be responsible for it and they need to keep it confidential. Termination clause. So again, it specifies when and how the agreement can be ended. We've gone through that. And dispute resolution, we have gone through. Some other things that maybe not included on this slide are warranties and representation. So for example, what kind of promises are you providing about quality or facts? Essentially, don't overpromise. That's the idea. So we'll go to the next one, which is key legal terms. And actually, no, sorry, we're going to continue this one. So warranties and representations. Again, promises or statements about facts, quality, or performance made before and within the contract. You don't want to warrant anything that you're not sure about, that you cannot guarantee. That's really, really important. But if you're, let's say you are again, the same scenario, you're a contractor, you're hiring a subcontractor. You want the subcontractor to warrant, to promise that they have the right licenses, that they have the right accreditation to be able to do whatever job you need them to do, that they have the right tools, they will be committed, they're warranting all these things, right? They're promising all these things. And so, yeah, super duper important. We'll go to the next slide. And then, yeah, coming off the back of that, there's some important ones here as well that I want to point out. Force majeure. So force majeure clauses excuse performance due to extreme or unexpected events. During COVID, obviously, these force majeure clauses were invaluable, basically saying that if for whatever reason, act of God or anything out of my control, that I cannot fulfill my obligations under this contract, um, I will be protected for a period of, let's say, 60 days, 90 days, 120 days, whatever it is. I am excused from doing my obligations, and you are excused from paying me for that. And that is because this is an act that is outside of our control. So during COVID, of course, now that was a super extended period of time. So a lot of the force majeure clauses expired at that time. But I think off the back of it, now we know, and we are drafting clauses and encouraging our clients to draft clauses that would work in scenarios such as that. Pretty much every contract I see now includes pandemic as part of the force majeure clause, whether it's, it used to list out different kinds of weather-related events like storms, floods, whatever. But now there's always a pandemic line in there as well, which is important. Um, and intellectual property is the other one that I want to call out here. So IP, I'm sure a lot of you know already, but super duper important. It's critical actually, and you need to make sure that your company owns the IP that you need to own. So, for example, in Australia, anyone that creates IP automatically owns it, right? If you pay me to create a website for your business, because I'm the one that created it, I automatically own it. It's my IP. Unless we have a contract which says that upon payment, my IP will be transferred to you automatically. So unless that document exists, then I will continue to own the IP. And that is a huge problem because anyone you engage to work as part of your business and create something, you know that you need to continue to own the IP. That's going to be critical when you're trying to sell your business or if you're trying to raise capital. The first question is going to be is where is the IP sitting of this software or of your website or of this data, whatever it is, where's the IP sitting? So you always need to make sure that it's assigned over to you. If for whatever reason it's left out of the original contract, we have things like an IP deed of assignment, which is again another contract. It's a deed which says that you currently own this and you are transferring it to this company on this date, as an example. So really, really important and critical, and it's important to get it right. Now we'll talk about some common mistakes to avoid. So these are like repeat offenders, the most common mistakes I see that time and time again, really. So, firstly, not reviewing key terms before signing. Many founders skip straight to the signature. That's risky. And it's not even just contracts. Like, even the terms and conditions is a contract, right? And I'm not saying that you're going to read every single terms and conditions, but the ones that are critical to you, the ones that matter a lot to your business, you should take the time to read everything and definitely every single contract. I know that too many business owners sign before reading the fine print. You need to check your indemnities, your termination rights, your payment terms. What are you actually signing up to? Secondly, failing to negotiate. Just because a clause is written down, it doesn't mean it's set in stone. Push back if it's unfair. Even large companies expect negotiation. This is a huge thing. I have so many clients that I work with that are just starting out, small businesses, or just launched their startup and they are getting a big contract with, I don't know, like a KPMG or just a bigger company. And they think that they can't push back, they can't negotiate because why would KPMG negotiate with me? But actually, that is the expectation in the sense that they're always going to send you a contract that is beneficial to them more. If you don't push back on it, then and you just accept everything, then you're kind of putting yourself in a worse position that you probably need to be. So it's worthwhile trying at the very least. What's the worst that can happen? They say no, and you should consult a lawyer as to whether certain clauses are critical to be amended or in the interest of progressing the deal, can we carry on with this and commit to it? Um, and then the last one is ignoring post-contract obligations. So clauses like confidentiality or indemnity, they often actually survive termination. Even if the contract is over, it doesn't mean that you can start revealing all their information now, right? The confidentiality clauses would continue to carry over after the agreement ends. And so it's important to keep that in mind. And a good rule of thumb is if you see the words survive termination, you should read that clause twice because it's definitely going to be critical. Um, and the one of the last things I'll talk about is when to DIY versus get legal help. So in some scenarios you can do it yourself, and in other scenarios you have to bring a lawyer in my opinion. So DIY works for things such as simple NDAs, basic non-disclosure agreements, or confidentiality agreements for maybe one-off conversations. You're talking to somebody about your business. Low risk supplier agreements, again, very standard deals, clear deliverables, low financial impact, and then repeat contracts that you really, truly, completely understand. So a lot of my clients are constantly hiring new employees and using the employment contract templates, and they understand it fully. They've used it before. They know that there's no change from this employee to this employee, and therefore they're happy to keep using it. And I highly recommend platforms such as Lawpath that help you with automation. Obviously, make sure you read every single clause, even if it's a template that you've used before. But these kinds of contracts, I think that you potentially could do yourself if you hypothetically wanted to. And then there's a lot of times when you probably should get legal help. So you should seek legal advice and bring in a lawyer because it can save time, stress, some serious money, especially when the risk is high. So definitely get legal help if it's a high value or a high risk deal. If there's complex language or unfamiliar clauses, um, if there's anything involving IP or equity arrangements, I know it says employment there, which I said earlier, you can do yourself potentially. It just depends on the complexity of it ultimately. There's some things, especially IP, that are legally sensitive and they carry long-term implications. And if you just don't understand, then definitely you need to be seeking help. And then cross-border arrangements, obviously, because jurisdiction does matter. And when there is other jurisdictions involved, it can get complicated. So think of legal advice as an investment. It helps you avoid some costly disputes later, which I see. Unfortunately, sometimes I have to come in on the time when when they're up to the dispute because they haven't sought legal advice earlier. That is also okay sometimes, but the ideal way is to obviously prevent yourself from being in that situation, and hopefully, yeah, just chat with one of us lawyers at Lawpath, and we would love to help. Um, Final takeaways before I end is that firstly, you should know your terms. So every clause means something, firstly. If it sounds confusing, that's your cue to kind of dig deeper and make sure you get a proper understanding. Number two is small mistakes can cost big. So missing a renewal deadline, agreeing to an uncapped indemnity, or skipping legal review. All of these things can have serious kind of consequences. And then finally, is you don't need to be a lawyer, but you should know when to call one. I think you can manage many contracts yourself, probably not all of them, but a lot you can. And so it's important to know when to bring in a lawyer when the stakes are high, if the terms are complex, or if you're unsure what you're agreeing to. It's important to know that contracts aren't just paperwork, they're the safety net for your business ultimately. And if you take one thing away from today, let it be this, that clarity up front saves you dispute and conflict later. And that's the most important thing ultimately for me. And yeah, that's all from me, guys. Thank you so much. I hope you got some value out of it. I'm sure we'll go through some questions later, but I'll pass over to Joel to let you know how LawPath can help you out.
Sahil, thank you so much. Sahil Bhandula, everyone. Thank you so much for walking us through the common contract traps that so many small businesses are facing at this stage. Real quick, what did we learn today? A single unclear clause like reasonable effort or as agreed between parties can create grey areas and disputes. Contracts often miss key protections like liability caps, fair termination rights, and clear deliverables. Small mistakes like rushing to sign or skipping legal reviews can lead to big costs later. And and I'd say it's not just about knowing what's in the contract, it's also knowing what's missing. It's a big one that we're facing all the time. I figured I'd just throw that one in there. Creating your own contracts and documents or having someone help you design it, it's not necessarily what's there, it's what's not there. Wow. I just had a bit of an epiphany. That's such a big one that a lot of people are dealing with at the moment. Sorry. Anyways, we've got a real story from one of our clients. Someone was kind enough to drop into us recently. One of our clients, a fast growing creative agency, shared confidential ideas with a prospective partner under the NDA that didn't actually define what confidential information meant. Months later, the partner reused those ideas, and the agency had no legal footing to challenge it. After joining our legal advice plan, we helped them review all client and contract agreements, fix the vague clauses, and put airtight contracts in place in just weeks, not months, guys, in just weeks. That's what proactive legal advice looks like, and that's what essentially saving money looks like through what Lawpath delivers. Now, let's address the elephant in the room for anyone who is interested in getting some assistance, either ongoing or just before the Christmas period when it's time to take a break. I know most years, especially around June or November, just before everyone goes on holidays, people are scrambling to get things done, so they're not going to be that, you're on the beach somewhere with your family or you're taking a break overseas in Europe. You don't want to be thinking about, oh, in 2 months time I got to get onto this, or as soon as we get back at the mid-January we got to fix this up. So if you are proactive and you do want to get something completed well beforehand, or if you are unfortunately one of those entrepreneurs who are going to be working throughout the Christmas period, this is how Lawpath can help. We'll begin with our essentials plan. Usually $468, now sitting at $324. This is a single payment. You have access for 12 months. You get unlimited legal document creation, which is about 554 documents, I believe we're up to at the moment. Smart workflows, AI assistance, and unlimited e-signatures. You can use this for NDAs, client contracts, HR documents, website terms and conditions, policies, and so much more. So that's your essentials plan at $324 per year. Then we have its big brother, the legal advice plan, now $1,500, which it's usually $1,668. You're essentially saving $648. With this, you get unlimited 30-minute phone or video consults with a verified lawyer. Sahil, for example, will be one of the lawyers available. You get unlimited contract reviews, both internal or external. You get to upload, request review, and get feedback fast. And you also get on-demand chat for fast answers. So if you are used to speaking with a lawyer who may be inundated with work, we can appreciate everyone's busy, and you have something that's bothering you, you can usually get a same day or next day consult with Lawpath as opposed to waiting 3 or 4 days. So that is the legal advice plan. If either of those interest you guys, I would mention that putting those two together just makes perfect. Personally, from speaking to our
We
clientele, having the legal advice without the documents is like having a car without a steering wheel, essentially. Looks good on the outside, but you're not going to be driving it. If you did want both plans together, we do have our bundle and save option. If you put the two plans together, you're looking at about 1,569 for those, as opposed to the 1,800, which it usually is. So you're saving 1,000 this Black Friday, essentially. And that is your document library and your legal advice. Then we have the gruesome twosome on the other end, the accounting advice plan, and the tax. Now, the legal and the accounting are operated the exact same way. You get unlimited 30-minute consults with a chartered accountant. He's going to teach you about general tax advice, GST, PayG, payroll, financial strategies, bookkeeping, invoicing, all of that good stuff. Same price as a legal advice, 1,500. And then the accounting's older brother is the tax compliance plan. Usually 3,600. It's now sitting at 2,688. The tax compliance plan isn't like the legal or the accounting where you're going to be doing a lot of DIY with the lawyer and the accountant working on everything. We're going to do everything for you. If you want your taxes done out of sight, out of mind, then we will do all of your BAS lodgements, your end of financial year reporting, tax return prep. You will get an assigned tax agent to handle everything for you. And yeah, look, essentially, guys, if you wanted to have everything under one roof, if you're a new business and you've got a bit of capital to spend and you don't want to have to go over here to a lawyer, over here for an accountant, and over here for a document library, you can have everything under one roof. Which brings us to our last plan. It's our big God bundle, so to speak. It's your essentials legal, accounting, and tax plan, currently sitting at 5,162. If anyone signs up to this plan here, you are privy to a $100 gift voucher. Now, this gift voucher isn't just for Lawpath, it's for anything. We've set that up there as a little pre-Christmas gift to everyone. So here's what you'll get after today's session for anyone who is new. You will get a full recording of today's session and the slides via email. You will get all of our partner offers through Zero, MyOb, Westpac. Everything will be in the email as well. I will update everyone with the prices and a dossier and breakdown of what you'd be getting with the legal, accounting, tax, or whatnot. And you'll also have a link to book a free legal or accounting consultation for 20 minutes as well. Bit of a try before you buy if you want to ask a few questions to get an idea of if is what you need now worth it, because we don't want anyone purchasing something through Lawpath if it's not necessary. We want to make sure that what you're getting is value, peace of mind, and obviously money saving. All right. If anyone is interested in having a chat after this with me, just to give them a bit of an update or talk them through what our plans provide in a bit of detail, you can just go ahead and put yes in chat. I'll put your name down and make sure that I reach out to you afterwards. You can just ask me a couple of questions and I can give you some more information. Other than that, let's go ahead and jump into the Q&A. So fortunately, nobody's thrown any questions into the chat. I believe there's just 3 questions in the Q&A. So Hill, if you want to grab them.
Yeah, thank you. Okay, from Matt. First question from Matt is one thing I've done is after setting up subscription with an iffy auto renew, I changed the payment method to a Visa debit with $5 on it. Smart, so it always rejects saving changes and any unfair cancellation terms. How does this fit in with these examples, and how would I protect myself on the other side? Great question, Matt. So I think that's a clever workaround, to be fair. Technically, using a low balance card to block charges, it can stop unfair renewals, obviously, but it is more of a defensive hack, right? Rather than a legal solution, I would say. On the flip side, if you're the business offering the subscriptions, you want to avoid as being seen as kind of trapping your customers, right? So the fair approach there is to include some transparent renewal terms, clear notice periods, easy cancellation, and upfront disclosure of charges, obviously. So that builds trust and it keeps you compliant with the law. And obviously, the Australian consumer law frowns on unfair contract terms and misleading renewals. And to be fair, if there's other companies out there doing that to you, you should call that out, call them out on it, and I'm sure they will be responding promptly. Um, Carmen, how would you handle moral rights in connection to IP? That's also a great question. In Australia, moral rights actually belong to the individual creator naturally. So they have the right, anyone creates something, they have the right to be credited for it, not falsely attributed, but credited for it, and to protect the integrity of their work, right? So even if you own the IP, let's say as a business owner, you own the IP, those personal rights for the creator still remain. And a practical way to handle this is through a moral rights consent clause. This is where we get a bit more technical in the IP world, but a moral rights consent clause into your contracts where the creator actually agrees that you can adapt or use their work without breaching those rights. It's a very simple clause, but it avoids disputes, and especially for creative or software projects, it is very, very important to keep in. And finally, one other question I have from Carmen is, would you recommend pushing back on terms as part of the RFQ tender process or wait until it's awarded? For example, if you're submitting a bid for a project under a RFQ process, and the form requires deviations from contract terms to be listed, any suggestions on how to actually manage this? Great question. And again, we deal with a lot of tenders as well. We deal with a lot of clients that are at the RFQ stage and trying to submit for tenders. So my general view is that you need to raise any key legal concerns early, but also strategically. So, we never want to put you in a position where you might not get the tender because of being difficult from a legal sense. But if the RFQ requires you to list deviations, you should do so, but you should limit them to critical deal breakers, in my opinion. So liability caps or payment terms, as an example, these are absolutely critical, and you can consult a lawyer on that as well. But keep it factual, keep it commercial, not combative, not like like don't do red lines out of ego. It's more just literally if you need to protect yourself, you can propose them as clarifications, if anything, rather than objections, I guess. You need to be careful, I guess. You're competing with all these other people for this tender. You also need to protect yourself legally. So it's finding the right balance, basically, in my opinion. Yeah. These are all the questions that I can see, unless you have more for me, Joel.
Oh, Glenn has gone and chucked a question in the chat. How can you possibly negotiate contract clauses with large organizations where, as a small business offering services, we rely on income from these organizations?
Yeah, great question. And I totally get it, right? You think that you're a tiny organization and this is massive organization wanting your services. And I'm not saying to, I guess, go all out and reject everything that they put in front of you. Rather, you're just trying to find a balance in the contract so that you can ensure that if things go wrong, that you are protected. You can also imagine if things go wrong, these guys are beasts. They're going to pull out their massive legal teams. They're going to do everything to try and I guess, crush you. So all you can do in the beginning is be as preventative as possible, try and have some balanced contract terms, try and set the expectations straight. It's easy for big companies to kind of just say that, okay, yeah, you're doing everything for us, X, Y, and Z, beginning to end. But if there's limits you need to place on the scope, there's limits you need to place. And regardless if it's a big company or small company, and I'm not saying every time they're going to accept it, but at least you start that conversation, let them come back to you, explain your point of view, and if you can negotiate it, great. More often than not, you'll find that they are actually open to negotiations and it's not a complete close off. So I do highly recommend it. Yeah.
Thank you, Sahil. Glenn, great question. Great questions from everyone so far. Thank you, Carmen. Does anyone else have any other questions, guys? It's been a good session. It's a rather quick one. We've got a couple more minutes left. If anyone has any questions, go ahead and chuck it in. We'd be more than happy to answer those for you. Yes, Matt, absolutely. I'll go ahead and contact you after this, and I'll be able to update you. And also happy to go over what you will need so we can confirm whether or not what we have to offer is exactly what you'll be needing. Tara, thank you so much for attending. Really appreciate it. Perfect. Look, I dare say that's everything. So everyone who attended today, thank you so much. I will go ahead and send the email out later on in the evening with everything from the slides, YouTube channel, etc. Yeah, Maria, I will send a version out for you via email this afternoon. So you should have everything in there, YouTube link, slides, and everything that we offer. Oh, here we go. One more. Richard Salisbury has asked, say if you have a patent and you are fishing for a company to buy IY, how do you not disclose too much?
So yeah, you have a patent and you're looking for a company to buy it. How do you not disclose too much? All comes down to NDAs. Ultimately, if somebody's going to buy something from you, they need to know what it is. They're going to ask you for the numbers. They're going to ask you for the details, and you know that you have to reveal that information, but also not shoot yourself in the foot. So what you need is an NDA. Anyone that is anyone that is reasonable, a reasonable buyer would be happy to sign a non-disclosure agreement and understand that they have to keep it subject to confidentiality to be able to engage in those discussions. Highly recommend. Quick one from Danielle. If you're entering into a contract with a supplier that doesn't have insurance, are there any ways to protect your company in relation to that supplier's work? Or should you demand insurance? You really should demand insurance. Ultimately, if the supplier owes you money, let's say they screwed up, they owe you $500,000, they don't have an insurance policy in place, and they don't have $500,000, it's really hard to recover that money. So you ideally should demand in your contract that they have insurance in place, and they should have insurance in place. And most businesses that I can think of. Thank you.
Thank you so much, guys. Great questions. Much appreciated. You have a lovely afternoon. Hopefully, where you guys are, the weather is great, and we'll see you next time. Thank you so much.